Our current judicial stance on implementing zoning restrictions for single-family homes has been unchallenged since the 1970s. This was decided with the case of the Village of Belle Terre versus Boras. In this case, a single-family housing ordinance banished 6 students from living in the ideal village of Belle Terre. However, as we will explore in a moment, this case should be challenged again in our nation's highest court of law. We think this case is summarized best by the quote from Mrs. Dickman, the owner of the house, referring to the city attorney in 1972. "There's absolutely nothing wrong with those kids. All they want is a quiet place to study. It's those old crows up there that are making all the trouble." The Supreme Court ruling did not provide adequate legal precedents or rational justification for the zoning ordinance. It infringed on the rights and freedoms of individuals to inhabit and utilize their property in the Village of Belle Terre community and failed to address the original objectives of the zoning ordinance. In the end, the decision-making process of the Supreme Court justices did not refute this statement from the Court of Appeals for the Second Circuit. Municipalities cannot, under the mask of zoning ordinances, impose social preferences of this character upon their fellow citizens. Therefore, the dissenting opinion of Thurgood Marshall was correct and rational. In 1970, the Village of Belle Terre passed a zoning ordinance prohibiting more than 2 unrelated persons living together. In December 1971, Dr. and Mrs. Dickman began renting out their house to 6 graduate students, including Bruce Boras. During their tenancy, 2 of the students were denied resident beach passes because they were violating the ordinance and thus were considered illegal residents. They were served a notice from the Village of Belle Terre for violating the zoning ordinance. In September 1972, the case was brought before the District Court for the Eastern District of New York. This court ruled the zoning ordinance constitutional. The appellees appealed the case, taking it to the Court of Appeals Second Circuit in February 1973, where it was ruled unconstitutional. On February 19th to the 20th in 1974, the case was argued before the Supreme Court. On April 1st, 1974, the Supreme Court decision was finalized, which upheld the constitutionality of the zoning ordinance, siding with the District Court. Before refuting the Supreme Court ruling, we should clarify our understanding of a few legal concepts. First, the right to privacy. Supreme Court cases interpret the right to privacy from the First Amendment, Third Amendment, Fourth Amendment, and Fifth Amendment. The freedom of association is also guaranteed in the First Amendment. It's related to the freedom of speech and is associated with the 1958 NAACP versus Alabama case. The right to due process is guaranteed under the 14th Amendment. Procedural due process is the promise of legality and fair procedure. Substantive due process has been interpreted to include rights such as the right to work any job, marry, and raise one's children as a parent. Finally, the right to equal protection is also included in the 14th Amendment. This refers to the idea that a governmental body may not deny people equal protection of its governing laws. The governing body, state, must treat an individual in the same manner as others in similar conditions and circumstances. In order to prove an issue with the right to equal protection, there is the need to prove harm from the discrimination based on scrutiny and suspect classification. Now that we've clarified the legal concepts involved, we can dive into the justifications behind each ruling. The District Court ruled the zoning ordinance constitutional. This court recognized that exclusionary zoning normally promotes traditional objectives such as safety, preservation of land from excessive use, or reduction of traffic congestion. They also recognized the validity to uphold the traditional family character of the neighborhood. The Court of Appeals for the Second Circuit reversed the decision of the District Court. They argued that it created a discriminatory classification unsupported by rational zoning basis. More specifically, they ruled that the exclusionary zoning ordinance was beyond the proper exercise of the state's police power. It protected the prevailing family patterns to the exclusion of all others. Belle Terre failed to show any factual relation between the ordinance and legitimate zoning objectives. Thus, the classification created by the ordinance was unjustified. The court viewed the right to live, where and with whom one pleases, as an important right entitled to protection under the new intermediate scrutiny formulation. The Supreme Court sided with the District Court, ruling that the zoning ordinance was constitutional. They ruled that there was no protected class discrimination or fundamental right infringement. They elaborated upon this by saying that the definition of family is up to the legislature, not the judicial branch. They also found that it did not restrict freedom of association. Finally, they agreed with the district court that it was valid for the town to uphold the traditional family character of the neighborhood and protect the peace and quiet of the community. Our argument is based on the dissent by Justice Thurgood Marshall, who said, "Zoning officials properly concern themselves with the uses of land, with, for example, the number and kind of dwellings. But zoning authorities cannot validly consider who those persons are, what they believe, or how they choose to live, whether they are Negro or white, Catholic or Jew, Republican or Democrat, married or unmarried." As mentioned previously, we argue that the Supreme Court failed to provide adequate legal precedents or justification for the zoning ordinance. The first reasoning from the Supreme Court was that in this case, there was no protected class discrimination and no fundamental right infringement. However, the zoning ordinance violates the fundamental right to live as you choose and where you want to, which can be argued is included in the right to substantive due process. According to Hopkins, the key to solve the distribution question is the equality of capabilities, not the equality of opportunities. With this zoning practice, the village of Belterre lowered others' capability to live in the neighborhood to ensure one-family dwellings are capable of receiving benefits from a homogeneous community. The Supreme Court ignored the right to equal protection under the law, superseding the wishes of other residents in the neighborhood to their property owners and the students. In this case, the right of non-single-family residents to live wherever they choose is discriminated as a whole. The village failed to address the interests of other parties as well. This zoning ordinance infringes on the right of the Dickmans, the property owners, to earn additional income off of their property. The court case cites the difference in rent for on-campus housing versus the Dickmans' house, which was much higher in rent, therefore preventing their ability to profit. Throughout the history of the United States has been the manifestation of the freedom to life, liberty, and the pursuit of happiness. It's important to remember the social context in which this case was argued. The village of Belterre is imposing a singular definition of family, which was upheld by the Supreme Court, given the societal standards of the time. By leaving this definition of family up to legislature, the Supreme Court is allowing the village to infringe upon the First Amendment rights of individuals in the town. Referring back to the dissent by Marshall, this violated equal protection. Municipalities cannot, under the mask of zoning ordinances, impose social preferences of this character upon their fellow citizens. In the words of Bancroft, this group of people are excluded because they contradict with the social norm. They are denied their right to privacy. The definition of single family is also not the purpose of the zoning ordinance. The ultimate goal of the zoning ordinance is maintaining the standards of the community, and the one-family restriction is the mechanism the town adopted. However, the town could achieve the same goal without redefining single family. The town wanted to get rid of extra car traffic, congestion, and noise. According to the ordinance, you could have any number of related people, also contributing to the noise, traffic, and congestion. But it's accepted because you're related by blood or marriage. The third justification from the Supreme Court was that the zoning ordinance does not restrict freedom of association. Freedom of association includes the right to live together. Students were members of the same social group, the university. They were taking collective action to pursue the interests of being school members and conduct activities together, such as living, studying, and hanging out together. The court actually denied the freedom of association by upholding the zoning ordinance, forcing students and other collective groups to seek residence only on campus rather than in the community of Belterre. The final reasoning of the Supreme Court was the zoning ordinance was justified because the city wanted to limit traffic, cars, and noise by a limited number of people. This is not rational based on two theoretical models. Drawing from Hopkins, there's a lack of means-end consistency. If the end is to limit high population and its effects on the environment and community, there are plenty of ways to do that. You can decrease speed limits and add roundabouts, impose a noise ordinance during certain hours, and put up signs warning of children at play. Drawing from Massop and Faludi, we can evaluate the zoning ordinance from the village of Belterre based on conformance versus performance. According to the performance principle, the zoning ordinance does not meet the goals of protecting a family-oriented community by kicking out the students. By all accounts, they were friendly, quiet neighbors. There's also no guarantee that the members of a single-family unit would not contribute to the problems of noise, traffic, and cars. Finally, Stein and Harper discussed the issues of egalitarianism and the tenets that Rawls defends. People of all backgrounds and classes deserve equal rights and opportunities. What parameters should be used to limit the number of people? Who should be excluded from the neighborhood to make others better off? The Supreme Court doesn't answer how far the town would be able to take this zoning ordinance in order to achieve their community goals. This is the main point behind Thurgood Marshall's dissent, hinting that this ordinance is a slippery slope to other forms of legal discrimination. Residents of the town could argue that the village is maximizing benefits for its residents, and therefore the Supreme Court's decision is justifiable. Less traffic, cars, and noise means better living environments. Clean air, access to green space, and a quiet environment could be considered public goods. Therefore, in the terms of Ostrom, they will be non-rivalrous and non-excludable. However, excluding residents that are not part of a single-family unit could ultimately fail because it does not regulate commuters' travel patterns. There could be the same amount of congestion, car patterns, and volume, and the same amount of noise, whether the residents in a single house are related by blood or marriage or neither. Hopkins summarizes the argument against the Supreme Court ruling best. Choices among systems of rights should depend on reasons of efficient or fair outcomes and on reasons of inherently preferable social structures. The ruling in favor of the zoning ordinance infringes upon the rights of individuals in New York, does not provide fair outcomes for all, and in the case of graduate students seeking a nice place to live, impedes on their preferred residential social structure. The Supreme Court failed to address the gaps pointed out by Justice Thurgood Marshall in his dissent, and therefore the ruling was not rational or just.